The live stream will begin shortly. Please note that RapidVisa is not a law firm and is not licensed to practice law in any state. The hosts of the show are not attorneys. RapidVisa is a document preparation firm, licensed and bonded in the state of Nevada. We will do our best to answer informational questions during the stream based on our experience in helping tens of thousands of customers successfully apply for their immigration petitions. However, if you need legal advice, we advise you to seek assistance from an attorney. Please post your questions in the comments section during the stream for a chance to win a $100 RapidVisa credit towards a future service. Now, enjoy the show.
Hi, my name is Rick. Welcome to RapidVisa Live, now streaming on YouTube and Facebook. Ask your immigration questions in the comments section during the stream for a chance at a $100 RapidVisa credit towards a future service. Stay tuned because the winner will be announced at the end of the show. Please try to make your questions thorough and in one single comment so we have enough information to address them. I'd like to introduce Pam, who's joining us today, and she's going to start us off with some immigration news. Take it away, Pam.
Thank you, Rick. Okay, we'll open up with some news. The Homeland Security recently issued a new public charge rule that our customers have been asking about, so we wanted to briefly go over this. A public charge, as defined by the USCIS, is a person who is likely to become primarily dependent on the government for subsistence, as demonstrated by either the receipt of public cash assistance for income maintenance or institutionalization for long-term care at government expense. In other words, a public charge is a person who cannot support themselves financially and depends on certain welfare benefits. People who are likely to become a public charge are not admissible to the U.S. and are not eligible to receive a permanent resident card. This has been the rule for so many years. There are two major factors that concern our customers about this new rule. The first major factor is the use of certain public benefits by the applicant. Now, any non-immigrant alien who is intending to adjust status and has used any public benefits in the USA, they would be denied a visa. The language of the new rule specifically mentions the alien and not the U.S. citizen sponsor. In this case, the public benefits must have been received directly by the applicant for the applicant's own benefit. The new rule, which goes into effect on October 15, 2019, mentions the following benefits considered: any federal, state, local, tribal cash assistance for income maintenance, supplemental security income or SSI, temporary assistance for needy families, TANF, federal, state, or local cash benefit programs for income maintenance, often called general assistance in the state context, but which may exist under other names, supplemental nutrition assistance program or SNAP, or formerly called food stamps, Section 8 housing assistance under the Housing Choice Voucher Program, Section 8 project-based rental assistance, including moderate rehabilitation, public housing under Section 9 of the Housing Act of 1937, federally funded Medicaid with certain exclusions. So in general, it's fairly uncommon for a non-immigrant to receive any of these benefits.
So the second major factor related to this new rule is the poverty threshold of the sponsor's income. The sponsor is required to meet at least 125% of the poverty guidelines. This has been the rule for some time and is not changing per se. But what is changing is that the Department of State is setting the bar higher, explicitly stating that if your income is below 250% of the poverty guideline, your case is going to receive more scrutiny. That means they're going to review it and they're going to look at the supporting documents, and they want to ensure that you meet this guideline. And just to give you an example of what 250% of the guideline is, for a family of four, you're looking at approximately $64,374. So that's considerably higher than it was before. Now, it's kind of a gray area on how they're going to scrutinize this because, as many of you probably know, income and supporting documents are very subjective, meaning that it's going to come down to the discretion of the officer reviewing the case. So you're going to need to provide more documents. They're going to look at your finances, and anticipate that we're going to see quite a few more RFEs, that's requests for evidence letters. We also anticipate we're probably going to see more denials. There's going to be a lot more information on this to come after the rule goes into effect, but what we can recommend right now is to submit your application or your petition as soon as possible. If you'd like to get started immediately, give us a call and we'll help you out with this, because we do expect this to have a major impact.
Okay, so we'll go now to some of the questions. This is from Miriam Alago from Facebook. Hi, in the DS-160 I am almost at the last part. It was asking for application case number. Where can I have that information? Is it the visa number or the USCIS number that can be found in NOA 2, which starts with WA? Thanks in advance for your response. I think it is the receipt number in the NOA.
There's two different numbers here. They're saying application number, but you're going to have a USCIS case number, and then you get a National Visa Center case number. And since they mentioned DS-160, I would probably assume that it's the MVC case number. But if you're not sure, give us a call, or you can even send us the letter. But if you're looking for the USCIS case number, that is on your NOA letter. That's your receipt notice you get from the USCIS. But if you're filing for the DS-160, that leads me to believe that you're at the MVC stage, and so you'd probably need your MVC case number. But we can help you with it either way. And also, when you're filling out the DS-160, they usually have little help icons and windows on the online form. And they usually spell out exactly which number they're looking for. If you need help with that, give us a call. We'll help you out. Next question comes from Hassan Ali on YouTube. My spouse's visa case has been returned to the USCIS on March 8th, 2019. After that, no updates are seen from the USCIS. How long will they take for reviews? And are they going to ask for a request for evidence, or are they going to reaffirm my case? This is a very tough question to answer because in the past, the USCIS would review the cases again after they were returned to the USCIS. But recently, I would say over the last 6 months or so, they have simply been denying the cases, stating that the validity date, that's the approval period, which lasts for 4 months, had expired, and they didn't give a reason why the cases were denied or why the beneficiary was found to be ineligible. In that case, I wish I could give you some better information, but recently what we've seen is that they're just sending a letter out stating that your approval period has expired. That 4-month period has expired. And at the bottom of the letter, they've been telling most applicants that they are eligible to reapply, and in some cases it says that this decision cannot be appealed. So a lot depends on what that letter states. If you'd like for us to review it, you can always send us a copy of it, and we could take a look at it for you and discuss it with you, discuss what some of your options may be. But in most cases, they're just denying them and telling the applicant to reapply.
Okay, next question is from Brian Tamayo. I'm planning to request an expedited request from NVC. Can RapidVisa assist on this? Unfortunately, we don't assist expedited requests, but you can contact NVC. Make sure you have the NVC case number, invoice ID, and all that stuff. But you, first and foremost, you have to have valid reason, because they could not just grant your request without any reason. One of that, I think, is urgent humanitarian reason. So you have to have valid reason. You have to contact the NVC and submit your request.
And just add to that a little bit, usually it's not the National Visa Center stage that you're trying to expedite. Usually you're trying to expedite the USCIS stage, simply because the NVC stage follows a process, and they actually move quicker than the USCIS stage. Usually you're looking at anywhere from 4 to 8 weeks at the National Visa Center stage. So usually there's not a reason to expedite, because usually if you've provided them with all the documents required to approve your visa, they usually move along rather quickly. But if they're delaying or your case is taking longer than 60 days, then you may want to contact the National Visa Center just to find out what's missing. But it's been our experience that once they have all their documents, the civil documents, affidavit of support, financial documents, they usually reach out to the embassy, schedule the interview, and then forward your petition on. So if you have delays there, I would call them and find out what the problem or issue is. Next question comes to us from Bong Jane on YouTube. My CR1 visa was sent back to the USCIS on February 26th. No feedback yet. What can be the issue? Everything was legitimate. My husband is a citizen, and we've been married since December 2016. Unfortunately, we're hearing this all too often for many of our applicants, and more so probably in the last 6 or 12 months, where cases are being sent back. And just to let everyone know why cases are sent back, it's because the consular officer did not have enough information or evidence to adjudicate the case. That means to approve the case. And in some instances in the interview process, the consular officer discovers new information that maybe they felt was not made available to the USCIS. In that case, they send the case back to the USCIS, and 12 months ago, the USCIS used to review the case. They could make a couple of decisions. They could either revoke the case, they could deny it, they could reaffirm it and send it back to the consulate or consular, the U.S. Embassy for adjudication. But unfortunately, what we're seeing lately is that they're just saying, hey, your approval notice is expired, case is closed. And I hope that doesn't happen with your case, but that's what's been going on lately. As far as what you can do, unfortunately, you just have to wait for that final decision. You need to see that letter and know what's going on. Also, if the alien beneficiary was found to be ineligible, you need to know why, what the cause of denial was or why they were ineligible. And the reason for that is because if you go to reapply for the fiancé visa or spousal visa, you may be denied again for the same reason or reasons. Okay, so you want to know the reason why you're found ineligible or why you're being denied, and you need to be able to overcome those reasons. So if you reapply, maybe you didn't prove that you had a bona fide legitimate relationship, maybe the sponsor didn't meet the financial income requirements on the poverty guidelines, you'll want to make sure that you gather up all that supporting documents, all the evidence, and so we can resubmit a much better, stronger case.
Right. The next question is from April Joy. April Joy from Facebook. May I ask if my fiancé visa will get approved and I will stay for good in the US and I want my kids to visit me there? What process should I do? I just want my kids to visit, not stay for good, because they want to finish their school in the Philippines. Okay, so if you just want them to visit you here in the US, the proper visa would be tourist visa. So the B1, B2 visa, we can definitely help you with that. They just have to prove that they have ties or they have every intention to return back to the Philippines, which I think being in school is one of the ground, but it all comes down to the discretion of the consular officer. So you can always try and apply for a tourist visa for them. That's the only way if you don't want them to stay in the United States.
Another thing to keep in mind too, if you're doing like a K2 follow to join visa, those visas are valid for 6 months. I'm not sure how long your children will be in school for, but that's just something to consider, that you could start the visa process and know that you also, right now the K2 follow to join process is taking quite a long time. I mean, it could be anywhere from 6 to 8 months. And then once that visa is issued, you have another 6 months on top of that. So something to keep in mind depending on your time constraints. But as Pam said, the tourist visa may be the best route, but just keep in mind that those are difficult to get approved for. There's quite a few denials on tourist visas, especially since the mother is already in the United States. You're going to have a difficult time proving that they have strong ties to their home country and that they're going to go back, because the consular officer is going to look at this and say, wait, you're just going over to the United States to stay. So you're circumventing the process. The consular officers don't like that. So anyway, you may have an uphill battle proving that they're going to go back. So I just want to set the expectations on that. Okay, next question comes from Darshani Chung on Facebook. Just to be clear, do you have to reach a certain income level to apply for your fiance? Yes, excellent question. For a K-1 fiance visa, you have to meet 100% of the HHS poverty guidelines. Okay, you'll have to take a look at that, and it depends on your household size. So if you have children or other family members in your house, or if your foreign fiance has children, you'll need to add those to your household size. And then you can look on the HHS poverty guideline, and it'll tell you exactly how much you have to earn in order to sponsor someone. So basically, the consular officer is looking to see that you can support these individuals or this person, and they will not become a public charge and collect means-tested benefits. Okay, that could be welfare, other things, like housing. Yes, you do have to meet the income. If you're not sure and you can't find the HHS poverty guideline, you can go on our website, and we have a calculator specifically designed to show you if you qualify or not, or meet the income requirements. You can also give us a call, and we'll help you out with that.
Okay, next question is from Michael and Heidi. Do the new October 15 income rules of 250% apply at the time of filing the affidavit of support or at the time of filing of the 130? I have a pending CR1, 130 waiting for NO82. So the new rule will take effect on October 15, and that would be all petitions that will be filed at October 15 onwards. So if you have already pending a CR1, it doesn't affect your petition, because it doesn't have a retroactive effect. It will only affect petitions filed on October 1 onwards. That's what I.
And the other concern here is, or the other question that we may not know about yet, is whether or not this is going to affect the affidavit of support filed with the consulate that's overseas. Right now, what we're looking at is adjustment of status packages filed with the USCIS. It's unclear at this moment how this is going to impact the I-130s and the I-485s, or the I-864s, which is the affidavit of support filed with the National Visa Center, which in turn sends it over to the embassy. But for your case, you should be fine. You've already filed, and you're well ahead of the game. But as I stated earlier, for anyone else out there, you really should apply as soon as possible, because once this goes into effect, we anticipate quite a few more RFEs, requests for evidence, as well as denials. We're not sure if they're going to request that you get a joint sponsor, or we're not exactly sure if you can use assets. So there's a lot of unanswered questions regarding this new rule that goes into effect in October. Okay, MyHawk2009 on Facebook states that my wife in Nicaragua changed her cell phone number. Do we need to inform the USCIS? Yes, I highly recommend that you update any and all information as soon as it changes, especially the cell phone number. And the reason being is because the consulate sends text messages. I know when I processed my wife's paperwork and her spousal visa, she received text messages when things were available, when the visa was being delivered. She received updates on that cell phone number. So basically, you filled out a form that basically tells the USCIS and the National Visa Center and the embassy on how to contact you. And I'm assuming, I would imagine, that phone number was provided. So you'll definitely want to update that information. If your case is at the USCIS, you can do that online with the AR11. If it's at the National Visa Center stage, I would contact the MVC. If it's at the MVC stage, you'll have the opportunity to fill out the online visa form, the DS-160 or the DS-260. You'll also have an interview, and they'll ask all this information again, but you'll have several opportunities to update this. But I recommend you update it immediately because communications will come and you don't know when they're coming, who they're coming from, and where they're going. So make sure your addresses are up to date, make sure your phone numbers are up to date, make sure they have the correct email address. All this stuff is very important because we've heard too many cases where an applicant stated, well, I didn't receive the communication, I didn't receive the text, the email, I didn't receive the interview packet at my home address. So I can't emphasize enough how important it is to update this information and update it immediately.
Okay, our next question is from Mercy Cesar. After biometrics, how many months to receive the work permit in advance parole? Thank you. So generally, as what we are seeing from our customers, they usually receive their combo card, their work permit, as well as the advance parole within 3 to 5 months. Now it's taking a bit longer, which is 4 to 5 months, but generally they will receive it within 3 months. And it usually is, it looks like a driver's license, which allows you to work and to live and re-enter the United States. So, but if you have not received your combo card within those months, then you might as well contact the USCIS center.
And just to add to that, if you don't receive the card within 60 days, I would start checking the status online with your USCIS case number. And if you don't know how to do that, contact us and we'll help you with that. But after 60 days, start calling, start checking the online status. We've heard too many cases where the card was mailed by the USCIS and it was never received. And also the same goes for RFE letters, requests for evidence. Letters were mailed out and the applicants didn't receive them. They didn't respond to the RFE in turn. They were denied. Just because we say, it could be 3 to 5 months, 4 to 6 months, don't just wait for that entire period waiting to receive this document. Be proactive. We try to join forces with our customers as a team to get their visas, to get their green cards, but we need their help as well as they need our help. It's a team effort, and what I can share with you is call the USCIS, check the case number. Just don't sit on the sidelines and wait, because the worst thing that can happen is that the card was shipped and you never received it. It went to the incorrect address. It was undeliverable, what have you. Just stay on top of it. And I would check the status every week after the 60-day period. I would call. And just also, please note that when you call the USCIS, they're backed up right now with the backlogs that they've created with all the requests for evidence. So it could take some time to get through. Just be patient. This is a very lengthy process. It's a very frustrating process. Just about everyone is receiving RFE letters now, so everything's just backed up. So I just want to set your expectations out there. I don't want to scare you or alarm you, but just don't expect, inspect. That's what I tell everyone. Okay, Andrea asks, is it possible for my American boyfriend to apply for sponsorship fiance visa while my annulment is still going on in the Philippines? Excellent question. And the short answer is no. Reason being, you must be legally able to marry before you can file your petition for a fiance visa. That means that you must have all prior marriages must be legally terminated, and your annulment paperwork, divorce decrees must be registered, certified, and they must be registered with the appropriate civil authorities in the Philippines. Obviously, that's the PSA. And then you also need a CNOMAR. You're going to need that at the interview. That's a certificate of no marriage. So basically, you can go ahead and get your account created. You can start filling out the paperwork. You can start collecting all the supporting documents and evidence that you're going to need. but you cannot file that petition because if you did file it with the USCIS, they would deny your case, and then you would lose that filing fee, the $535. You'd lose all that time because it would probably take them 4 to 6 months just to look at your case. And then once they noticed you were still married, they would just flat out deny your case. So no, do not file that paperwork until you have your annulment. And I know annulments take a long time in the Philippines. They can take anywhere from 12 to 24 months unless you've had it expedited or something, but just make sure you get that first.
Yeah. The next question is from Jim Birkin. Okay. Will the K1 visa income requirements going up in October 15, or is it just adjustment of status, 250%? Are you able to get a co-sponsor once in the United States? Oh, another 250% question. The income requirements.
Yeah, just to let everyone know out there, the income requirements are not going up, okay? If you'll look at the HHS poverty guidelines, the income requirements have stayed the same.
Yeah.
Okay, the only thing that came out with the new rule from the U.S. Department of State is stating that they are looking at incomes in between 125% and 250%. Those are the ones they're going to scrutinize more. Okay, so if your income is over 250%, say it's over 65,000, you're going to fly through with no issues, okay? But if you're below that 250% level, they're going to scrutinize it more. So they're going to look for more evidence. They're going to look at several factors. They're going to look at your age, your health, your employment, okay? Whether you're retired, whether you're receiving Social Security. They look at a lot of different factors. There's the USCIS actually has a document out there that lists all the factors that they look at, and they take all this into consideration, and they just want to ensure that the beneficiary is not going to collect means-tested benefits, okay? Food stamps, welfare, things like that. But if you are below that 250% income level, in some countries, at some embassies, you may use a joint sponsor to meet these income requirements. But if you're from the Philippines, not so much. They do not accept joint sponsors for the K1 fiancé visa. They do for the spousal visa, but not for the fiancé visa. So again, we don't have all the answers on this new rule yet. There's a lot more information that's going to come out, especially once we start receiving RFEs and denials. Because usually in those RFE letters, the request for evidence letters, they'll tell you exactly what they're looking for. They'll tell you you need a joint sponsor, or we need to see your IRS tax transcript from the previous year or the last 3 years. So what we expect or anticipate is that they're going to be looking for more. So I can tell you, usually to prove your income, they want to see your last year's tax returns, and they want to see your W-2s. And we also recommend providing 3 to 6 months of your pay statements. If you're a business owner or independent contractor, a lot of times you're going to want to provide 6 months of bank statements, including all your tax schedules. So again, with this 250% rule, there's a lot more to come on that, but right now just know that the income requirements have not gone up. It's just this is giving them some more leeway, I think, to scrutinize petitions more. So yeah, more to come. All right, the next question comes from Felix Nature on YouTube. I attended my CR1 interview last week. At the end of the interview, the consular collected my passport and said we'd get back to you in 2 weeks. My case is now placed on administrative processing. Are they going to deny me? They didn't give me anything. Okay, just to let everyone know, administrative processing does not mean that it's denied or approved. This just means that they need more time to review the documents, supporting evidence, and the overall case in order to make a decision. And as of late, I would say in the last 6-12 months, I would say probably almost 30-40% of the cases go into some kind of administrative processing. That's not uncommon. It's not anything to get overly concerned about. They're just looking into the case more so. They're scrutinizing it a little more. And a lot of times it's also because the consular officer didn't feel like he or she could approve it, so they escalated up to a supervisor level. Now, in most cases, if they needed more documents or more supporting evidence, they would issue another letter. Usually it's called a 221G, request for evidence. And you may still get that because it's at their discretion. They can submit an RFE at any time. And not to alarm you or anything, but we've also seen cases where they were under administrative processing for 4 to 6 weeks. And then next thing you know, they received a communication or letter, or they saw the status update online that stated that the case was being returned to USCIS. I would just keep in contact with them. As long as you're proactive and being active with the case, they'll keep it open. But unfortunately, you won't know the outcome or the actual status until you receive the communication, until they make a decision, whether it's a recommendation to revoke or approval. Hopefully you'll get your approval notice, check the status online, and also if you can, contact the U.S. Embassy. Also, please keep in mind that some of the embassies are very difficult to get a hold of. A lot of times you'll only receive a recording when you call, and it's very difficult to get through. So you just have to be patient. A lot of times you just rely on that online status. Also, most of the embassies have an online inquiry. It's an email address, and we've heard that some customers have achieved success with that they can get a reply within a day or two. You may try that as well.
Okay, next question is from Michael Heidi. Is the Philippine Embassy rule of no joint sponsor for K1 still apply? The new 250% income requirement will significantly impact K1 visas there. Yeah, unfortunately, Philippines still would not allow joint sponsor. So there's also one country, I think it's Thailand. So they don't accept joint sponsors for K1. And but they do accept liquid assets if you have liquid assets to supplement your income. If you think your income is not over 250%, so you can actually supplement your liquid assets such as your properties, real properties, bank statement, bank deposits, and stocks, and all that. Or you might as well go there and get married. So
okay, I just want to reiterate, because I don't want our phones blowing up and our chat lines and our support lines blowing up on this income requirement. Okay, please note, okay, the income requirements have not gone up. Okay, for a K1 fiance visa, they are 100% of the HHS poverty guidelines. For a spousal visa adjustment of status, they are 125%. Okay, this 250% is basically just a line they're drawing in the sand saying if you fall below this, we may scrutinize it more. This doesn't mean they're going to. It doesn't mean they will. It doesn't mean that you're going to receive an RFE, or it doesn't mean you're going to receive a denial. I think it's just the administration's way of putting more obstacles out there, more roadblocks. They've already slowed the process down quite a bit with the RFEs, requests for evidence, and everything. I think this is just one more thing that they're going to use in their toolbox, if you will, to scrutinize petitions more so. So right now, I don't really see anything to be overly concerned about or alarmed about until we know for sure. And we're not even 100% certain that this is going to impact the consular officers and their decision-making process and the National Visa Center stage or the embassy stage. Right now, we know for certain that it's going to be at the USCIS stage, okay, primarily for adjustment of status, applying for green cards. That's when you submit the Form I-45 and the I-64 and several other forms. But right now, it looks like they're focusing on folks applying for the green cards here in the United States because the first part of that rule, if you heard about that, it's looking at the beneficiaries who have received means tested
Benefits.
public benefits in this country. So it really looks like they're kind of focusing on people inside the United States. We're not quite sure or 100% sure how it's going to impact cases and petitions overseas. So again, as soon as we get an update on this and we hear more information, stay tuned to our RapidVisa Live. You can also look at the news that we post on our website. We will be following this closely because as I can see, this is already going to be a hot topic. And we understand your concern. Trust me, we do. And it's going to be a huge impact for us as well. So we're definitely going to keep on top of this, and we'll have more information for you, I promise. Okay, next question comes from Maria Ramirez on YouTube. National Visa Center keeps asking for the same documents. I submitted all the same docs I submitted with the I-130, which is approved. What's going on at the MVC? Excellent question. A couple things could be at play here. With the National Visa Center stage, they've switched over to electronic document processing. That means that you have to scan and upload the documents. Now, we've had experience with this here at RapidVisa, and if your format is not exactly correct, they reject the documents. So you may have to submit them over and over and over. Now, if it's something that the MVC actually received and then they're requesting it, that could mean that there's a problem with the actual document you submitted. I'll give you an example. A lot of birth certificates from foreign countries are called short forms, meaning they do not have the parents' names listed or both parents, but on a birth certificate, you have to submit the long form, okay? That has all the pertinent information on it, both parents' names, things like that. So I would have to see the RFE that you're receiving, request for evidence, because a lot of times they'll spell it out. They have a detailed checklist of everything you'll need. You can also take a look at the reciprocity schedule online with the U.S. Department of State, and they list documents by country, and they give you the requirements for that country. And so the USCIS and National Visa Center will follow the standards of the foreign countries. So there's a couple different resources you have there. Look at the letter you received. Usually they provide detailed information on exactly what they're looking for. But also, if you're unsure, if you keep having problems with, give us a call. Maybe we can assist you with it. We've had a lot of practice after getting over 50,000 visas and petitions approved. We've actually gone through this quite a few times. So you can give us a call and maybe we can assist you.
Okay, next question is from Baktower. What happens when RFE is approved? When do they give you the visa then? Okay, assuming you have, complied with the RFE, submitted on time, they usually resolve the RFE within 2 to 3 weeks or even a month. It depends, that's just an estimate because it depends on the nature of your petition, the type of petition you're filing. So they will usually resolve it within 2 to 4 weeks, generally. When do they give you the visa? Well, they give you a visa once your petition is approved. So you just have to wait for the notice that will be mailed to you. And yeah, they will for sure notify you when your RFE is approved and when your visa will be approved.
Now, you don't state what type of visa it is. So there's different processes and different stages for different visa types. If it's a fiancé visa and you received a RFE, or request for evidence, at the USCIS stage, once they approve it, then they will forward your petition on to the National Visa Center, where they assign a case number to it, and then they'll send it on to the U.S. Embassy. And then your visa is not issued until after the interview and the consular officer approves it. On a spousal visa, it's a little different, whereas the National Visa Center collects a lot of the documents, the affidavit of support, financial documents, civil documents, then they pass it all on to the embassy, and the consular officer will again perform the interview, approve it. So again, to answer your question, when the visa is issued, that's after the consular officer approves it. And after the consular officer approves it, it's usually 7 to 10 days for them to print the visa in the passport and to deliver it. Now, that time varies by country, but it's usually 7 to 10 days. Okay, next question comes from Asaji Michael on Facebook. Had my interview for adjustment of status from K1 on 20th of August. The interview went smoothly. Within 20 minutes, the officer said we were good, but she will have to review and mail our card if everything is okay. But it's been almost 21 days and my case is still under review. Should I be worried? The short answer is no. Everything's backed up right now. And I know that's starting to sound like a broken record, but with all the caseloads that the USCIS has and all the RFEs that they've submitted, they're really backed up. And so 21 days, although that does seem like a long time because usually they'll issue the visa after it's been approved, or not the visa, but the green card. You can check the status online. Also, if it's gone beyond 30 days, I'd probably call the USCIS just to make sure that it hasn't been mailed to the incorrect address. Also, make sure that all your information is up to date. If your address changes, phone numbers, email address, anything changes, make sure that's updated as soon as possible. But 21 days is nothing to get concerned about. I mean, we've actually heard it going even into 3 or 4 months. I hope that doesn't take that long with your case. But the main thing to remember is stay on top of it. Don't let this time go by forever and just expect that something's going to show up, because sometimes it doesn't always.
Okay. Next question is from Jose Guevara. This one is very interesting. Do you have experience filing a writ of mandamus against a U.S. consulate, specifically the country of Morocco? Writ of mandamus. No, we don't.
No, you'd probably want to consult with an immigration attorney on that. Any of you have followed RapidVisa Live or know about RapidVisa? We primarily focus on family-based immigration visas. That includes fiancé visas, spousal visas, visas for children, parents. We also focus on adjustment of status, the lawful permanent resident card or green card. We do not file waivers for anyone. You're going to need to consult with an immigration attorney. There's a lot of cases that we just don't take. If they require an attorney, like if you want to file something like this or an appeal, we would recommend that you consult with an immigration attorney. Okay, next question comes from Yang Nora on Facebook. I received my combo card after 5 months. If I travel outside the country, how many days do I need to be back in the U.S. for a family reunion as a reason for the travel? This travel documents or parole would allow me to travel. Excellent question. Yes, you can travel on the combo card. In the current environment, it's not something I recommend until you get your actual green card or permanent resident card. Just because there's so many things that can go wrong. Okay, we've heard of so many cases where an applicant received an RFE while they're out of country, and they didn't respond to it. Usually, depending on the letter, you may have 30 days to respond. I've seen letters that state that you have 87 days. To answer your question, generally you can travel outside the United States for up to 180 days, but that's usually with the green card. But I would be cautious about traveling while waiting for the green card. For instance, what if something happened, you didn't respond to the RFE, they canceled your case? Now you may not even be able to get back into the United States. So again, yes, you can travel on the card. I'm not trying to scare you, but if it were me, I would probably just wait. Now, I know you stated you have to go back for a family reunion, anyway, hopefully you're not going to stay out of the country very long. I mean, most people that travel usually only stay out for a week or two and not extended period of time, because the other thing is the officers are looking to see that you're actually wanting to stay in the U.S. and not just visit, and not using this green card application or your combo card or temporary card as a tourist visa or something. So just keep that in mind. I mean, usually it's 180 days that you're allowed to travel. I definitely do not stay out beyond that. You can file an extension. That's not something that we do at RapidVisa, and not something I recommend either, but that is available too. But you could contact the USCIS on that if you need more time.
Okay, the next question is from James Sibal. In applying the 130 or spousal visa, I am applying for 130 spousal visa. Do I need a joint account as a requirement, or joint sponsor? Also, will my political opinion cause a problem because freedom of speech is very limited? Okay, so if you're applying for spousal visa, you don't need to get a co-sponsor if your income is, if you meet the income requirement, which is 125% of the HHS poverty guidelines. Now, if you fall below that, then that's when you really need to get a co-sponsor to help supplement your income. As to your second question, also my political freedom of speech, I don't think that is a problem. Is that freedom of speech is limited?
I guess the only way it could be an issue or problem is if you had something posted on social media, and because they are now looking at social media records and the review process, and yeah, it's difficult to say what the consular officers and USCIS officers are going to review and how they're going to take that. Basically, everything comes down to their discretion. As you know, we're not associated with the government. We don't approve visas. We just assist in the processing of paperwork. Okay, and it looks like James is asking another question here. If my wife is pregnant, but not sure how that'll affect the spousal visa, and is it still available for applying birthright citizenship since I'm a U.S. citizen? So let's take the first part first. When someone's pregnant and it shows up in the medical exam, in some cases we've heard where they asked or requested the petitioner to sign an affidavit stating they were aware that the applicant or the beneficiary was in fact pregnant, especially on the K-1 fiance visas. So just keep that in mind. You may have to sign an affidavit stating that you are aware that the beneficiary is pregnant. And then on the second part, if your child is born overseas, you're going to want to file a CRBA. That's called a Consular Report of Birth Abroad. You can find more information on that on the U.S. Embassy website. Most embassies have an entire page dedicated to that. Gives you step-by-step instructions, and they'll give you the requirements for supporting documents. But you'll want to have the birth registered. You'll need the birth certificate, and then just follow the instructions. But you'll file all that paperwork directly with the U.S. Embassy. And the beneficiary may even be able to do that without your presence or assistance there. You'll just have to check on what the requirements are for the particular country that you're in.
Okay, so next question is from Ahmed Darik. What are immediate relatives? Okay, so immediate relatives for purposes of family visa application, they include your spouse, your children, and your sibling. It doesn't include your grandparents, no. So these are just limited people. Yeah, parents, of course, yeah, parents.
Okay. All right, Khan asks, states, my K-1 visa has been denied under section 212A 5A. What should I do? If I'm not mistaken, I think that deals with labor certification and qualifications. That's not something that we usually deal with here at RapidVisa, since we primarily focus on family-based immigration visas and not work visas. So if you stated that your K-1 visa was denied, I'm not sure why a labor certification would come into play on this. You may want to contact the USCIS or consular officer, and just to clarify or make sure that you've got the right section number of the INA and the because that at least what we're showing is that's for labor certification. That shouldn't be a part of the K-1 fiance visa unless maybe something came up in the interview stating that you were looking for employment in the United States, so they're looking for this labor certification. You may also want to consult with an immigration attorney if you did confirm that's what the reason why you're being denied is because of that. I've never seen that before personally, at least not with a family-based immigration visa. So clarify the case or the section number of the INA, and if that is in fact the correct number, then yeah, consult with an attorney.
Yeah.
I'm not sure where to go with that one.
Okay, next question is from Benjamin Zuta. My fiancé is unemployed. Will I be approved at the interview stage when we get approved for NOA? Okay, so when your fiancé is unemployed, obviously he will not be able to meet the income requirements. So that is one very important eligibility if you apply for any family visas. So if he's unemployed, that calls for red flags. We highly recommend that you find a joint sponsor. A joint sponsor is anyone who is a U.S. citizen or a permanent resident who is currently residing in the United States and who meets the income requirement. So there is no way that the petition will be approved without meeting the income requirement. It's really very important. Or you can also provide assets if you have assets to supplement the income. But just be aware, because assets, they usually scrutinize it more, and it is also discretionary on the part of the reviewing officer whether or not it is sufficient. So there's that.
Okay, Reina Mendez on Facebook asks, what is the next step after the appointment for biometrics, the I-765 and I-485? So after the biometrics, you're usually looking at probably a couple months after that to get your temporary card. That's the combo card. Has your employment authorization document, your travel permit. Then probably, I'm guessing maybe a month or two after this, you're looking at an interview, okay, with you and your petitioner and sponsor. And then after the interview, hopefully that goes well. And then a few months after that, hopefully you'll receive your lawful permanent resident card or green card. So the whole process right now is taking anywhere from 8 to 12 months. It used to be about a 6 to 8 month process, but that's extended by quite a bit now. Some of the cases are going up to 12 months. But anyhow, the next thing that comes after the biometrics appointment is going to be your combo card and then your interview.
Okay, next question is from LFE. Okay, what happens if my fiancé didn't get an interview date before his application deadline for visa? Every time my fiancé checks, it's saying no available dates. He just got a date, but it's after the deadline. Should we be worried, or is that normal? We have seen this from countries, from our customers. We are seeing this from countries from Nigeria, Ghana. So what we always advise them is to call the embassy, because it's only the embassy who can actually help you with that. Yeah, so yeah, it is really important that you call the embassy. Do not just sit there. Call the embassy and ask them what to do, because yeah, this is actually normal for countries, for those countries as I mentioned. So, but most of them went through. So yeah, just call the embassy and verify the dates, verify whether or not you should be setting up another interview date again, because we have these cases now, and it's quite normal.
And just to let everyone out there know, as long as you're being proactive and your case is still active, you're still pursuing the visa, in most cases they will automatically extend that eligibility or that validity date on a case, and the consular officer has that discretion as long as you're still following through, keeping in contact. What you want to do, call the embassy as Pam stated, make sure that you're working this and that you're not just letting time pass by, because if time passes by, they will eventually send your case back to the USCIS, and the USCIS will state that the validity period has expired and with no visa issued, therefore this case is closed. So stay active, contact the USCIS, and generally, you know, I think a lot of times that the officers at the embassy have access to a calendar or schedule that most cannot see online. So I would try and work with somebody internally if you can, because we've heard, like Pam said, quite a few times where the dates just aren't available. Some of these embassies are small. They don't process as many visas as some other countries, and they just don't have the